Simon Ekpa's court session began with strong opening remarks by the presiding judge, who emphasized discipline, relevance, and evidence-based arguments from both legal teams, urging them to avoid speculation and focus on justice. Both the prosecuting and defense lawyers affirmed their commitment to a focused, respectful, and evidence-based process. They promised to present arguments within legal limits, guided by the court's directions. The judge reminded Simon Ekpa of his obligation to provide full disclosure of the contents of his digital devices, including phones, tablets, and laptops, as a condition tied to the consideration of his bail. Simon Ekpa stood and confirmed his readiness to comply, expressing willingness to present the content of his electronic devices. He emphasized his transparency and said he was acting in good faith, fully prepared to follow the court's instructions. Simon then gave a detailed presentation of each device. His tablet used mostly for reading and note-taking. His laptop, which included professional documents, legal research, and access to cloud platforms. His 2 mobile phones that contained call logs, text messages, social media apps, and synced emails. He assured the court that no data had been deleted or altered, and stated he was open to placing his devices in the custody of either a forensic expert or a court-appointed officer, asking only for fairness and speed in the process. The prosecuting lawyer responded cautiously, acknowledging Simon Ekpa's gesture, but asserting that simply showing the devices in court does not prove transparency. He requested a full independent forensic analysis to properly verify the integrity of all data. The prosecutor further requested that the devices be officially handed over to a court-appointed digital forensic analyst with a proper chain of custody maintained and all passwords securely submitted to prevent tampering. The prosecuting lawyer also asked to cross-examine Simon Ekpa, which the judge approved. The cross-examination began with basic confirmations about the devices and Simon Ekpa's claim of not tampering with any data. During questioning, Simon Ekpa stated he regained access to his devices only shortly before the court session began. The prosecutor aimed to establish how long Simon Ekpa had physical control over the devices, hinting at concerns over possible data manipulation during that time. Prosecutors grilled Simon Ekpa about managing his own digital devices without assistance, raising concerns that he could have tampered with data before submitting the devices for court examination. Simon Ekpa admitted to having full control over his phone and laptop and acknowledged using apps like Signal and Telegram, but denied deleting or altering anything intentionally related to the case. He confirmed that some of his devices were synced to cloud storage platforms like Google Drive and Dropbox, but had not yet granted the court access to these accounts. Under questioning, Simon Ekpa conceded that some messages might have been deleted, either automatically or earlier by him, but claimed nothing relevant to the case was erased. The prosecution requested that Simon Ekpa provide full access credentials to his encrypted apps, cloud accounts, and devices, arguing that his word alone couldn't be trusted without independent verification. A digital forensic expert was brought in and testified that deletion logs showed several WhatsApp and Telegram threads had been manually deleted from Simon Ekpa's phone just hours before the court session. The forensic analyst also found advanced cleaning software installed on Simon Ekpa's devices, used shortly before court, which had capabilities to permanently delete data beyond basic cleanup. The expert stressed that the deletions appeared deliberate and not system-generated, though he couldn't recover every file's content, only metadata indicating deletion patterns. Simon Ekpa's lawyer began cross-examining the forensic expert, challenging the reliability of forensic tools in proving a person's intent and raising the possibility that some deletions could have occurred automatically. The court session ended with the cross-examination still ongoing. The courtroom in Helsinki, the capital city of Finland, was once again filled with a tense, expectant atmosphere as the trial of Simon Njoku Ekpa resumed in full force. The date was June 26, 2025, and every eye in the room, from journalists to legal analysts to curious observers, was fixed on the events that were about to unfold. Everyone in the room understood that the court session today would not only shape the immediate direction of the trial, but also test the character, credibility, and strategic depth of both legal teams. The presiding judge, a calm yet firm woman known for her procedural discipline and emphasis on integrity, entered the courtroom promptly. After a brief moment of quiet acknowledgement to the audience and the legal representatives, she began the day's proceedings with carefully chosen words. She reminded everyone present that the aim of the trial was to establish the truth based on evidence, not rumors or emotionally charged arguments. She said that both the prosecution and the defense were expected to respect the decorum of the court and conduct themselves with professionalism. She urged them to stay on track, focus on relevance, avoid unnecessary speculation, and always return to the central pillars of justice: evidence, law, and fairness. Both the prosecuting and defending attorneys nodded respectfully. They expressed their mutual commitment to honor the court's expectations. The prosecuting lawyer, representing the Finnish government, promised to present his evidence with clarity, transparency, and within the strict confines of the law. The defense lawyer, representing Simon Njoku Ekpa, assured the court that they too were committed to providing clear, honest, and evidence-based responses while maintaining respect for the judicial process. There was a shared understanding that although they stood on opposite sides of the legal battlefield, the duty to serve justice was shared by all. The judge then turned directly to Simon Njoku Ekpa. Her voice became even more deliberate as she reminded him of one specific condition that had been tied to his consideration for bail. She said that unless he fully disclosed the contents of his digital devices, including mobile phones, laptops, and tablets, the court would not be in a position to properly evaluate his intentions or trustworthiness. She clarified that this was not about punishing Simon Njoku Ekpa, but rather about ensuring transparency and trust in a sensitive legal process involving digital evidence. Simon Njoku Ekpa stood slowly and confidently from where he was seated. His face was serious, his expression solemn but steady. With a voice that was calm and respectful, he addressed the judge directly. He said he fully understood the condition placed before him and was ready to comply completely. He expressed his willingness to present the full content of his devices and confirmed that he was acting in good faith. He assured the court that he had nothing to hide and was eager to cooperate with every step of the legal process. After being given the opportunity to elaborate, Simon Njoku Ekpa took the court through each of the digital devices in question. He began with his tablet, a compact device he said he mostly used for reading and taking notes. It contained articles, e-books, and court-related materials. Then he moved on to his laptop, which he described as his central work device. He said it included professional documents, communication with legal teams, research files, and access to various cloud platforms where some of his data was stored. Lastly, he mentioned his 2 mobile phones. These, he explained, contained his call logs, text messages, a variety of social media applications, and his email accounts, many of which were synchronized across different platforms. He firmly told the court that none of the data in his devices had been deleted or modified. He offered to hand over the devices to either a court-appointed official or an independent forensic expert. He requested that the process be carried out quickly and fairly so that his legal defense would not be delayed or compromised. He looked straight ahead as he spoke, and there was a brief moment in the courtroom where many could feel the weight of the occasion. A man standing accused, defending his right to be treated with dignity while submitting to scrutiny to prove his innocence. The prosecuting lawyer, however, responded with visible caution. He acknowledged Simon Nyoku Ekpa's willingness to cooperate, but reminded the court that simply showing the devices in court or offering verbal assurances was not the same as providing verifiable transparency. He told the judge that there had to be an independent forensic investigation to confirm the actual state of the devices. In his words, trust must be backed by evidence. He requested that the devices be formally handed over to a digital forensic analyst who would be appointed by the court. He also asked that a proper chain of custody be maintained to ensure that there was no interference or tampering with the evidence. Furthermore, he said that all passwords and access credentials needed to be submitted securely. The prosecuting lawyer then asked for permission to cross-examine Simon Nyoku Ekpa, which the judge granted. With permission secured, the prosecution began questioning Simon Nyoku Ekpa. The initial questions were straightforward. They confirmed that Simon Nyoku Ekpa had physical possession of his devices. They asked him to verify the number of devices he owned, which ones he used regularly, and which ones had access to his cloud storage platforms. He answered all the questions openly, stating that he had indeed used the devices in question and had access to accounts like Google Drive and Dropbox. He also confirmed using encrypted messaging applications like Signal and Telegram. But the questioning soon took a sharper tone. The prosecutor began to focus on the time frame between when Simon Nyoku Ekpa regained access to his devices and when the court session began. He wanted to establish whether there had been any window of time, even a few hours, during which Simon Nyoku Ekpa could have altered, deleted, or concealed data on the devices. Simon Nyoku Ekpa acknowledged that he had regained access to his devices shortly before the court session, but strongly denied having used that time to tamper with any data. The prosecution was not convinced. They argued that simply having access created the possibility of manipulation. They grilled Simon Nyoku Ekpa on whether he had assistance from any digital expert or technician to manage or secure his devices before presenting them to the court. Simon Nyoku Ekpa replied that he handled everything himself and did not consult with any third party. He said he believed in maintaining control over his own personal and professional tools. The prosecution continued pressing him. They suggested that someone with knowledge of how cloud accounts and encrypted applications work could easily remove sensitive information without leaving an obvious trace. Simon Nyoku Ekpa firmly denied having deleted anything related to the case. However, under continued questioning, he admitted that some messages may have been deleted automatically by the apps or by him at an earlier date before he was ever called to court. He emphasized that nothing important had been intentionally deleted. At this point, the prosecution made a more serious request. They asked the court to compel Simon Nyoku Ekpa to provide complete access credentials, including passwords, to all of his cloud-based accounts, encrypted apps, and digital platforms. They argued that relying on his word alone was not sufficient. Independent digital verification was necessary for a fair and complete investigation. The judge took note of the request but did not immediately issue a ruling. Instead, She called in a court-appointed digital forensic expert who had already begun examining the devices earlier in the day. The expert, a well-respected analyst in Finland, walked up to the witness stand and swore the oath to tell the truth. The atmosphere in the room shifted as the audience sensed that something critical was about to be revealed. The forensic analyst gave a calm but detailed explanation of what he had discovered during his preliminary analysis. He said that metadata logs from one of Simon Yoku Ekpa's phones showed that several messaging threads on WhatsApp and Telegram had been manually deleted just hours before the court session began. He explained that the deletions were not automatic and were not the result of routine device cleanup. Instead, the deletions were initiated by a user with full access to the device. He further revealed that the devices had recently been used with advanced cleaning software. This software had capabilities that went beyond regular deletion. It could permanently erase data and remove even the digital fingerprints that would normally remain after a file is deleted. The analyst said that this kind of software was designed for secure data destruction. He clarified that while he could see deletion patterns and timestamps, he was not able to fully recover the deleted content. He could only confirm that something had been deleted and when it happened. The courtroom was silent for several moments as the implications of the expert's testimony settled in. If Simon Yoku Ekpa had in fact used software to delete information shortly before court, then his claim of transparency was now under serious doubt. However, there was still a legal gap to cross. Proving deletion was not the same as proving intent. Simon Yoku Ekpa's lawyer stood up and began cross-examining the forensic expert. The defense lawyer pointed out that while metadata could show when something was deleted, it could not explain why. He said there were many reasons files get deleted, some innocent, some automatic, some accidental. He also challenged the reliability of the forensic tools used in interpreting intent. He asked whether it was possible that some deletions happened automatically as part of app updates or security features. The forensic expert acknowledged that in rare cases, automatic deletion could occur, but he maintained that the pattern he observed was consistent with manual deletions done within a short time frame and using professional cleaning tools. The analyst repeated that while he could not say with certainty what was deleted, the method and timing were concerning. The judge listened carefully to the cross-examination. She remained neutral but attentive. She allowed the defense lawyer to continue questioning the expert in the next session, which she scheduled for the following day. As the court session came to an end, many observers left the room with mixed feelings. On one hand, Simon Yoku Ekpa had shown a willingness to cooperate. On the other hand, the forensic testimony raised serious questions about whether that cooperation was genuine or simply a calculated legal move. Outside the courthouse, reactions were divided. Supporters of Simon Yoku Ekpa expressed their unwavering faith in his innocence. They said that the system was looking for ways to criminalize activism and that Simon Yoku Ekpa was simply a victim of political persecution. Others, however, expressed concern that trust had been broken. They felt that the discovery of manual deletions and the use of advanced cleaning tools could not be ignored, regardless of one's political views. The defense team huddled in private after the court session, preparing their arguments for the next day's session. They understood that everything now depended on how well they could explain the deletions, challenge the forensic evidence, and protect their client's credibility. The prosecution, on the other hand, seemed energized. They believed they had found a crack in the defense and were determined to widen it by bringing in additional digital evidence in the days to come. And so, the courtroom drama continued. The trial of Simon Yoku Ekpa, A man whose voice had echoed across continents in his call for self-determination was now centered on data, silent, technical, coded evidence that could either convict or exonerate him. As Finland watched, and as the world listened, the trial moved deeper into its most critical phase, one where truth, memory, and technology collided inside the cold walls of a Finnish courtroom. When the trial resumed the following morning, the weather outside the courthouse in Helsinki was cloudy and cold, matching the somber tension that now hung in the air. People gathered again inside the courtroom. There were reporters seated in the back rows, typing notes into their laptops. Legal interns sat beside senior lawyers, observing every detail. Supporters of Simon Ekpa stood outside, some holding banners, others whispering prayers. It was a courtroom surrounded by pressure, questions, and the burden of truth. Inside the courtroom, the presiding judge entered and immediately called the session to order. Her face was calm, but her tone was sharper than the day before. She looked at both the prosecution and the defense teams and reminded them again that the court had zero tolerance for deception, obstruction, or attempts to mislead the court. She said that while every accused person is presumed innocent until proven guilty, that presumption can be damaged if the individual is not fully honest with the court. She then invited the defense to continue their cross-examination of the court-appointed forensic expert. The defense lawyer for Simon Ekpa stood up, adjusted his black jacket, and walked calmly toward the witness stand where the forensic analyst was seated. He began by thanking the analyst for the work done so far. Then, with a soft but determined tone, the defense lawyer began to raise questions about the limitations of digital forensic technology. He pointed out that forensic software can detect file deletions and metadata timestamps, but it cannot always detect the content of deleted files or determine why a user deleted something. He asked whether the forensic analyst could say with absolute certainty that Simon Ekpa's deletions were aimed at hiding information that was directly relevant to the case. The forensic analyst responded honestly. He said that he could not confirm the exact content of every deleted message, but he could say with confidence that the pattern of deletion and the tools used were highly deliberate. He emphasized again that the cleaning software installed was not something casual users typically install. It was the kind used by professionals who know how to permanently wipe data beyond recovery. The analyst stated that this suggested not just deletion, but a calculated effort to prevent retrieval. The defense lawyer then brought up the possibility of regular system maintenance. He said that some users install cleaning apps to free up space or protect their devices from malware. He asked whether it was possible that Simon Ekpa had used the cleaning tool for general maintenance rather than destruction of evidence. The forensic expert acknowledged that possibility in theory, but stressed that the timing of the deletions, just hours before the court hearing, combined with the use of deep cleaning settings, made that explanation less likely. The judge listened quietly, writing notes as each side presented their arguments. At one point, she paused the exchange and addressed Simon Ekpa directly. She asked him whether he had anything else to say regarding the cleaning tool and the deletions discovered. Simon Ekpa stood up once more. He said that while he had installed the cleaning app months ago, he had used it routinely without giving it much thought. He said he was not aware of how powerful the software was and did not intend to erase anything relevant to the case. He maintained that he had nothing to hide and insisted that he was still willing to provide access to his cloud accounts if the court required it. The judge took a deep breath and nodded. She then announced that she would consider whether to issue a formal court order compelling Simon Ekpa to submit all passwords, including for encrypted messaging apps, cloud drives, and email accounts. The judge added that if Simon Nyoku Ekpa wished to avoid this order, he could voluntarily cooperate before the next court session. She made it clear that non-cooperation could be viewed as an obstruction of justice, which might affect decisions about his bail and the overall handling of the case. This is the end of our news update. Please click the icon on the top right corner of your screen to watch my next video. You will enjoy it. I will see you again in my next update. Enjoy the rest of your day. Goodbye for now.